The contents of the jail call is concerning for the state.
Case number C25392-959-1, State of Nevada versus Jordan Cristos. On behalf of the state, Ms. McKay, Ms. Rose, on behalf of defendant, Ms. Muije, he's present in custody. This is time set for sentencing. Is there any legal cause or reason why we can't proceed today?
No, Your Honor.
Sir, did you review a copy of your pre-sentence investigation report? Is everything in there correct, sir?
Yes.
Okay, and this is a stipulated felony treatment, no out probation with the first 180 days in the Clark County Detention Center, starting from the day of his arrest that was to run concurrent with his other case. And previously we were on for sentencing, and I did have a concern about the negotiations, and we continued it so I could see the prior reports related to your other cases. And I was provided with that information. I also had a discussion with both parties with regard to the negotiation and why it was negotiated the way it was. And anything else? Anybody want to add anything else?
Judge, I just wanted to add for the record, I understand that it has, it's not because of this case specifically. I handled the 23 CR 067295 case. In that case, Mr. Cristos was advised multiple times not to have any contact with myself nor the department. This morning I received an email from Mr. Cristos that was entitled wrongfully incarcerated with his family court documents attached. I knew that he was in custody, so obviously I know that Mr. Cristos is the one who sent the email, so I listened to his jail calls earlier this morning and provided that to defense as well as a transcript. The contents of the jail call is concerning for the state, given the fact that he knows and is very well aware that he's not supposed to have contact with myself or JC7. And I received the family court document. Granted, again, I do understand that there will be an argument made that he didn't mean to send me the email based off of the jail call and what Mr. Cristos is saying this morning. However, it's very clear that he has no contact. In the contents of the jail call, it's having him direct somebody that has his cell phone to send a message, to type in Laura Rose, send it and forward it to defense. Now I understand that is taken, that his explanation is that he meant to forward the email to his defense counsel, not to send it to me. However, the email that I received was a brand new email. It wasn't a forwarded email, or it wasn't like a reply email. It was a new email that was sent to me in JC7. In addition, the contents of the jail call, again, I did not have time to listen to his jail calls. I don't know what the context of the jail calls are. However, he says something along the lines of send Bobby a text and let him know that when I get out, I'm ready to fuck shit up. I'm ready to win. Obviously, I don't know the context of that call. I don't know what he meant by that. My concern is that he was under a court order not to have contact. His behavior in my case, predating his arrest from house arrest, is very concerning for the state, given the fact that he was outside of the RJC trying to contact people about myself, outside of Clark Place where you know the district attorney's office is. It's concerning for the safety of both the district attorney's office as well as the victims in this case if he can't follow simple orders while pending sentencing, especially the day before the sentence. Now, granted, I understand that he's going to have his side where it was a common mistake, but when there's such circumstances that happen that would insinuate something very different, it's hard to take those representations as the truth. So with that, Your Honor, I do think it's relevant to this proceeding, but I'll submit to the rest of the court.
Ms. Muije.
Yes, thank you, Your Honor. As to this part of the argument, I do object to everything the state has brought forth. We do have an stipulated agreement here. The state has also not regained the right to argue based on any of this contact. As Ms. Rose just stated, I did, since speaking with you this morning, review the transcripts and listen to that portion of the jail call. I believe what happened was Mr. Cristos was asking this person who is out of custody to forward an email that was previously sent to Ms. Rose to myself. I think that was the request of Mr. Cristos. However, this person who is out of custody seems to have gone somewhat rogue, I'll say. And sent emails to Miss Rose, sent emails to the other departments, as well as sending emails to me. I can tell you for certain, Mr. Cristos never directed that individual to send any emails to the judicial departments. So that person has created a lot of this issue here when Mr. Cristos was only trying to get a document sent to me. And so I do not believe that this information should be considered when sentencing Mr. Cristos today, as Mr. Cristos was only trying to get me a document in preparation of sentencing today. And this negative contact is actually conducted by someone unrelated to this case.
Okay. I do think it's relevant to my sentencing determination. Obviously, it's not a violation of the instant plea agreement, but the reason that we continued this previously, because the court already had concerns based on his prior history, based on the repetitive behavior, based on, in my opinion, what seemed to be escalating and then clearly escalating after I reviewed the reports. And I think that had this happened prior to our conference, that it would have been brought up at that time. So it would have been relevant at that time. And so I'm considering it. Obviously, I still know the state has to stand by their position of no approbation, but the court's concerns still remain. So that being said, Mr. Cristos, would you like to say anything on your behalf prior to the pronouncement of sentence?
Bobby is my backer in poker. He gives me money to play high stakes poker online. I was referring to my friend, he's a believer. He knows I'm gonna win massive. I've done very well in poker in the past, and that's all. And I'm very sorry for my behavior and what's happened in the past. And I promise it will never happen again. I've learned a lot from this experience, and I've got really deep, and it's been very hard for me. I just want to get back to my children, and I'm very sorry. And that's all.
Mr. Cristos, Ms. Muije, anything else?
Yes. When we're considering a sentence and a negotiation, I believe we need to look at the approach to sentencing. Retribution, rehabilitation, deterrence. As for retribution, Mr. Cristos has been punished in multiple ways. He has been in custody on this case 126 days at this point. That is the longest period of incarceration he has ever been subject to, and I can assure you that this has been a punishment for Mr. Cristos. We have talked many times over the course of his case, and I can tell you this has affected him greatly. Additionally, as he said, the most important thing in his life is being a father and his two sons, and being away from them has been an extreme punishment for him as well. Additionally, being on probation and having those restrictions will serve as an additional punishment, and he will have a felony on his record that, if he does not earn the drop down, will carry punishment for the rest of his life for his actions. So in terms of retribution, he definitely has seen the punishment aspect from this negotiation and hopeful sentence today. As for rehabilitation, the state and I asked and dealt this case to probation so that Mr. Cristos can receive help and treatment. Your Honor, you can give him impulse control, anger management, therapy, all of those things. Give him all of the conditions so he can work on correcting his behavior. And the other, reason of probation is that he can be supervised. And so we can ensure that he's being supervised at all times. He can be on an ankle monitor to ensure that he's having no negative contact with any of the named victims here today. And then we go to the third step, which is deterrence. I can tell you, again, Mr. Cristos has felt the punishment of his actions. So hopefully already what has occurred will act as a deterrence for him to have no further negative contact with anyone. But also the probation aspect will act as a deterrence. The drop down, I feel, also acts as a deterrence in this case. He has a massive incentive to do everything that is expected of him, to meet all the requirements you're going to give him, to have no negative contact, to just focus on being a dad. So our negotiations were crafted considering retribution, rehabilitation, and deterrence. Your Honor, also, I understand everybody's concerns, but this negotiation will have Mr. Cristos supervised. He can be on the ankle monitor. This is meant to keep him from having any negative contact with anyone. I know, we all know here that if Mr. Cristos violates in any way, shape or form, he will be sent to prison. So really, this is one chance for Mr. Cristos to do what we are all asking of him. I ask that you do follow our negotiations, and also I stated for the record at our entry plea, but I'll state again, that the Alfred plea was at direction of counsel to help in his custody case. It's not that Mr. Cristos didn't want to take accountability for his actions. So again, he has 126 days towards the 6 months. I do ask that you follow the negotiations to place Mr. Cristos on probation.
All right, thank you. Mr. Cristos, in accordance with the laws of the state of Nevada, you hereby judged guilty of attempted stalking with use of internet or electronic communication. The court will treat it as a felony. You order to pay $25 administrative assessment fee, a $3 DNA administrative assessment fee, and $150 DNA analysis fee, and you're ordered to submit to genetic marker testing. Mr. Cristos, I had concerns the last time we were here for sentencing, and I'm not inclined to follow the negotiations, and I'm not obligated to do so. I am extremely concerned by your prior history, by your repetitive behavior. I do understand rehabilitation. However, it's clear to the court that even when you've had help and you've had the required counseling, that for some reason, if you don't get something, doesn't go your way, that you continue to harass people and you continue to even violate multiple times prior orders. So that is very concerning to the court. And I also have to consider community safety. I did again read all the reports related to your prior cases and the one, including the one to be dismissed in this negotiation. So that being said, you're hereby sentenced to a minimum term of 14 months, maximum term of 60 months in the Nevada Department of Corrections, with 126 days credit for time served. You are ordered to have absolutely no contact with Regina McConnell or Adam Pliska in any way, directly or indirectly. Do you understand, sir?
Yes.
All right, thank you. Good luck to you.